Okay, I would like to begin our program by once again introducing Dr. Abraham Warrenklein, the chairperson of our Continuing Educational Credits Program. Dr. Warrenklein.
Good morning again. It's my great pleasure as well to introduce to you Dr. Michael Bone. Dr. Bone is well known in the field of parental alienation. He has been doing evaluations on parental alienation for almost 3 decades. Dr. Bone is president of JMB Consulting, which provides educational and consultative services to both parents and attorneys and other mental health professionals in cases involving the alienation of children. It is my great, great pleasure to introduce Dr. Bone.
It's my great pleasure to introduce the first speaker, the keynote speaker for today, Dr. Richard Sauber, whom I've known for a number of years and had the good fortune to work with in cases involving parental alienation. There's a small group of people in the United States and Canada that really work in this field, and Dr. Sauber is certainly on the very, very short list of those most important in this field. So it's a great pleasure to be able to introduce him today for you. Dr. Sauber has been 30 years practicing forensic psychology, board certified in family and clinical psychology, trained at Harvard. He served as expert throughout the United States and Canada, formerly professor of family and clinical psychology in the Department of Psychiatry, the medical schools in Columbia, Brown, and University of Pennsylvania. In the latter 2 schools, he was also the director of their postdoctoral training program in family psychology, in family therapy, and forensic psychology. He has been on the founding board of directors of the Academy of Family Mediators, National Academy of Professional Custody Evaluators, and also serves on the advisory board of the Children's Rights Council. Dr. Sauber has also been editor-in-chief of the international peer-reviewed journal, American Journal of Family Therapy, which I happen to have a copy of right here. And I would very much suggest that you take a look at that and keep in tune with this journal, as there'll be an issue coming out that is devoted to this Canadian symposium, which we're very excited about. What else can I think to say? It's a great pleasure to have Richard here, and you're certainly in very good hands for the next hour and 15 minutes. Thank you.
Thank you, Dr. Bone. In thinking about the title of the presentation this morning, which is Forensic Evaluations, I thought about, why would anyone want to do a forensic evaluation? Now, there's a variety of fields you could do it in, and I've done employment law, criminal, medical malpractice, personal injury, and that's pretty straightforward and enjoyable and challenging. But when you think about family law, I mean, if somebody had said, would you want to be involved with bungee jumping or something like that, I'd say, of course not. I'd be far away from anything that was risky or dangerous, but yet doing a forensic evaluation in the family law field every day is a risk, and there are landmines, and how to be aware and be prepared when you know something's going to come from the other side when you're not looking. And it reminded me of when I first got involved in this field many years ago. There's a colleague whose name may be familiar with you, Robert Woody. He's a JD PhD, significant figure in the American Psychological Association, and his full-time practice is representing psychologists with Department of Professional Regulation complaints. And when I got my first complaint, frivolous as it was, of course called my friend Bob and asked him to represent me. And he said, the first thing you want to do, you're a member of good standing with the American Psychological Association, and he's a leader within that organization. He said, you want to resign. I said, Bob, why would I want to do that? He said, because when there's a complaint and you're working in the custody field, in the alienation field, people are going to complain whenever there's a group to consider a complaint against you. Well, you have your state regulatory bodies and professional organizations. And within APA, they have ethics committee and some pretty good, capable people that like to examine complaints. So I had to go through a double scrutiny process with the American Psychological Association, reviewing this complaint of nonsense, as well as the Florida board at the time. So once I was cleared of those kind of complaints and charges, I'm trying to remember what it was. I think it was, I was in a deposition, and the person in which I was being deposed about complained about confidentiality during a deposition, which is nonsense, because once the privilege is waived by their giving permission for their attorney to ask questions, it doesn't make any sense to issue a complaint about that. Nevertheless, I did resign from the American Psychological Association upon the advice of my buddy, and still support the organization, but not from a membership point of view, because when you work in this field, you can expect to have complaints. There's always a disgruntled party, and often the attorney of the party that's in an unfavorable position will not want a report that's damaging to their client to have the weight that it deserves, so they will encourage their client, why don't you file a complaint against this doctor? And when I go before the judge, I'll say, he's being examined by the state ethics committee for inappropriate ethical conduct, potential malpractice, and all kinds of things, which puts the judge in a position, how's he going to give credibility to this kind of testimony when the state is evaluating a complaint? So that's a real problem. And when I do or accept these kinds of cases, I wonder, why am I doing this? There was one case in Orlando that a colleague here had asked me to get involved, and later apologized repeatedly because the mother involved had filed complaints about 3 prior psychologists. And I kind of expected, here I go, why would I walk into this situation? And the attorney was able to file a motion for enjoin, which meant that prior to a complaint being filed, the person had to file a complaint with the presiding judge in this case. So at least it was a preliminary before the state got involved with it. Nevertheless, there was nothing to stop anyone to file a complaint. And Florida is recognized as one of the states that advocates we protect our public, meaning we encourage our citizens to file complaints, particularly about professionals. Fortunately, I haven't had many complaints, all of which have been dismissed, but it does involve hiring an attorney, making your records available, and from what I've recently learned, it's not the basis of the complaint that they look for, it's the basis for anything. They go on a fishing expedition trying to find some reason to find fault with the professional. So why do this kind of work? And in asking this question, I guess what the answer I come up with, especially in doing psychotherapy for many years, that's a slow process in which the results are mixed. And you often wonder, when you start with clients, how much impact you can make on their lives. Whereas when you do a forensic evaluation, it's a relatively short period of time, and especially with PA cases, you can dramatically alter the outcome for the lives of the children as well as the targeted parent. I guess you can have an impact on the alienating parent in the sense that they are rendered powerless, but in terms of any rehabilitative fantasy. That certainly doesn't make any consideration of making a positive impact on the alienating parent. So that's why I enjoy doing this kind of work. It's challenging, and it certainly keeps you on your toes because you have an opposing attorney, whether you're court-appointed or otherwise. There's always one side that's out to get you once they know what your position is, and they hire their experts to try to find fault with what you found. And a judge doesn't want to hear findings about parental alienation syndrome. Judges, as you may have gathered, really don't like to make decisions. They like to go with the flow. And when you have a case of PAS, judges don't want to go against the tide and disrupt families and turn over children to a parent that they hate and disrupt their family life, their friends, their school systems to extract the child or children from one household onto another. Nevertheless, that's the challenge, not only to present your findings, but to influence a judge in a way that helps them do their job with the appropriate evidence. What I'd like to do is just give an overview of how you approach a forensic evaluation that's PAS related, and to offer a case example of the kind of terrain that you easily walk into doing these kinds of cases. And for those of you that do this kind of work know that this is pretty common, that you don't walk into a neutral playing field. You walk into one where the poison has been cast and the people know already who they favor, and you're not on their popularity list. So the presentation description is there are certain procedures to follow as either a court-appointed or retained expert in PAS cases. Case presentation will illustrate how a court-appointed custody evaluator, a child psychologist, a parent coordinator, and an attorney guardian ad litem recommended sole custody and supervised visitation to the wrong parent, missing the correct diagnosis of PAS, and how a limited PAS-related evaluation was able to refute the mistaken findings and alter the process and outcome of the trial. Well, how do you get involved and how does it start? You get a phone call from typically an attorney, or an attorney gives your name to a client to call, and they ask for a resume. Either they're familiar with your work or they heard of your work. And one side generally seeks you out because you have some experience with PAS and understand it, whereas particularly a targeted parent has difficulty finding people familiar with PAS. And a lot of people say they know about it, they have experience with it, but it's quite another consideration when you know how to work with a PAS victim. So your name is then submitted along with several other names. Now, the attorney requesting your name generally submits 3 names. And then the other side submits 3 names. Now, when you're considered a PAS expert, really it's not just to go in and prove a case of alienation. It's equally true to rule out an allegation where the parent says they're alienated when in fact they're not. So it's really both sides of the coin. So what happens is the attorneys go back and forth. Once an attorney recommends you, the other side doesn't want you. Once they find out that you have PAS related to a resume or that you've done work in the field, right away the other side doesn't want you. In fact, I had in one of my resumes PAS work, and one client said, could you remove the S and just put PA, parental alienation. Then what happens, the other side likes to select people that are unfamiliar with PAS had a case out of Indianapolis where the attorney for the father, who was a targeted parent, submitted my name with several others. The mother was residing with her parents in Atlanta and submitted 3 resumes of internationally renowned professors at Emory University. 2 were psychiatrists, all of which were unfamiliar with PAS, specialists in ADHD and a variety of other unrelated topics to PAS. And the attorney for the father was able to convince the judge that none of these people were qualified. So that's the first step, getting through the process of elimination and screening and getting appointed. And I get large numbers of phone calls, can I have your resume? And the likelihood of being appointed is limited, questionable, and a small number end up retaining your services, not related to qualifications or in a way related because you're too experienced in doing this kind of work. Nevertheless, then you're appointed. Now, you could be appointed in one of several capacities. The one that is most potent is one of being court-appointed or appointed by agreement between the attorneys. In this way, you're considered impartial. You're agreed upon by both sides to do a full evaluation that's unbiased, as opposed when you're considered a retained expert for one side, then you come in and you're already the hired gun, and your credibility is questioned. Those of us that work in the field want to use to an advantage those cases listed on our testimony list that indicate that those people that have hired us, we've testified against many of those people. So we can document that whether one side pays or retains you, you still ultimately seek out what is the truth and the outcome that is the legitimate one, and not because you were paid to seek a particular finding. So you could be retained in one of these particular aspects. And often if your start as a retained expert, you can't go back and be an impartial court-appointed expert. But what you can do is, working with that attorney and client, help guide those people to the names of other individuals that are familiar with PAS to help at least load the deck so that the person that is court-appointed is familiar with that. There was one case I recall where I started off as a retained expert for one party, and fortunately was able to give the name of a colleague that has experience with PAS to be the court-appointed. So in this case, this was a father who had the advantage of 2 experts in PAS, but we had a judge that was unfavorable and didn't want to hear about the concept, and the father still lost despite 2 experts and the same findings in support of a PAS finding. So once you're selected for the role, let's say it's impartial, court-appointed, it can be one of a variety of different motions that are submitted to the court. And these motions may be in the form of what's called a PAS evaluation. That's a rarity where the judge is able to entertain and deal with PAS up front. Generally, it's disguised as a custody evaluation or a psychological evaluation. Now, these 3 titles do vary in terms of their emphasis, and there are subtle differences, but when you get to the bottom line, there's a common denominator, so you're doing the same thing regardless of what it's called. And the bottom line really is looking into the shared parenting responsibility doctrine. Is there shared parenting responsibility? And certainly with a targeted parent, there's a violation there. And the other has to do with co-parenting and shared decision-making, and is information exchanged between the parents. And often you find on a school registration form, one parent registers themselves and excludes the other parent. Or in hospital records or physician records, one parent is excluded and never told about medical visits, things along these lines. So these are helpful findings, whether it's called a psychological evaluation, looking at what are the psychopathological factors or substance abuse among the parties involved, or custody in terms of the best interest of the children, or alienation, which goes to contempt of some of the state guidelines for shared parenting. I have a slide, if you could put that up on the screen. And the slide that I selected is just one slide, and it's a chapter 6113 in the state of Florida. If whoever's doing the slides would make that available. It's a list of the criteria upon which judges, attorneys, and experts use for the best interests of children. And since the slide's not presented, I'll make reference to it as we go along. It was? Okay. Oh, now I'm sure you can all read that with, otherwise you have visual impairment, and you must be a targeted parent. Okay, well, I'm sure you absorbed that content of that slide, so we'll move on. So let's say you're doing a PAS evaluation, whatever it may be called, and there's three considerations. One, is it a real PAS case? Is the criteria and symptomatology for PAS really present? Or is it a pseudo-PAS case where there's an appearance of alienation, but there really isn't one? And frequently I get probably slightly more cases that are appearances of PAS that are not. And an example of that case would be one in which a parent says, I'm experiencing difficulties with the other parent, the child dislikes that parent, and there's interference with time sharing. It reminds me of a case in which I was involved, and the father went to great difficulty outside the state of Florida to find me, retain me, and have his attorney pounce on the judge to get an appointment. And then I ended up testifying in favor of the wife, the mother, former wife. And what happened in this case was his daughter, he thought, was alienated from him, but in fact it was because of poor parenting skills. This fellow was raised in the mountains of a mining town. He had 6 brothers. Had very little exposure to females. His mother was a subservient figure in the family. And he had no idea how to relate to women, no yet a daughter, a young child. And he told me, oh, he has a great time with his daughter, who is attached to this little stuffed animal. And when visiting with him, he would hold it out the window and joke with her that he was going to drop it. And why should she be attached to this stuffed animal? After all, I don't know, she's 8 or 9 years old at the time. He couldn't understand why she would be upset and not think this is humorous. Or he would go shopping at the food store at night and leave his daughter alone, and she would have night terrors and wake up and her father wasn't there, and beg him, don't go to the store at night shopping, take me with you, wake me up. And what he said is, I didn't go food shopping, I was here all the time. I just didn't hear you. So in a session between the father and the father kept denying the fact that he would leave his daughter alone, until finally I said to him, unless you are honest with her, how can you ever have a relationship with her? And if we're comfortable enough that when you make a promise you're not going to leave her alone, that she knows you're not going to leave her alone. And he finally admitted during the appointment that he would not leave her alone anymore, and he apologized for leaving her alone. So this daughter, this young child, did not want to spend time with him. The mother respected the daughter's wishes. She had her own faults, but nevertheless, there was not a case of PAS. It was a case of this individual needing parent skill training to know how to relate to a young child, female, his daughter. And then there are cases that all of us have experienced where the continuum of, is it abuse? And every time there's an alienation case, the targeted parent is accused of abusing that child. And that's why the child doesn't want to see the parent. And a horrible mother, horrible father, drug addict, and all the rest with physical and emotional abuse issues. And often the A-bomb is dropped, which is the child molestation, in which there renders a victim somewhat helpless. The judge says right away, we have to stop visitation until we find out it's safe. We have to even question supervised visitation. And then that adult's career and every other aspect of their life begins to go downhill. So we look at the variables involved in a real case of PAS. First, you have a malicious parent. It's interesting, the article that many of you are familiar with is the malicious mother syndrome. That was submitted to me with the American Journal of Family Therapy years ago. It was the only article ever accepted for publication in which the managing editor of the journal, at the time it was Brunner Maisel in New York, which was the major mental health book publisher, overrode my decision to accept it. And I had to call the author and say, we can't accept it for publication. Publisher just felt that this was such a rarity, and how could we give mothers such bad press? But now the term malicious parent is more or less accepted in the literature, and the article was published in another professional journal. And the malicious parent knows no boundaries. So what one would expect is never what we find, because I certainly don't think in those terms, and who among us here would think in terms of how does a sociopath and a narcissist think and plot and plan? And they come up with ideas that I could never even imagine. But I guess the more you do work in this field, there are no surprises. So that you find when you start interviewing a family, one party has all the charm in the world, and behind the charm is the sociopathology and narcissism that allows them to do what they end up doing. You have the targeted parent that's desperate, distraught, emotionally and legally bankrupt of what to do, and asks for a PAS evaluation. Because what else can they do? They're in this position. A PAS evaluation is never the first line, it's the last line of attack and effort for the targeted parent to get some remedy to justice. And what we always find is a well-meaning mental health therapist or counselor who is involved, who has become aligned with the alienating parent. Rarely do we have a case without a mental health professional supporting the alienating parent, who believes everything the child says, distrusts the targeted parent. The well-meaning professional already has formulated an opinion, not subject to change. I always hope that somehow I can persuade the mental health professional that maybe their alignment is misguided, but they don't want to challenge their own professional stance and ego and admit that they're wrong. And they're so well entrenched in supporting the alienating parent that we just have to move on just knowing that that's just one more obstacle to deal with in the path. Because the alienating parent has told many terrible stories about the targeted parent, from neglect to abuse of the child, which has been confirmed, and I put that in quotes, from the child, from Bard's scenarios, a term we're all familiar with from Dr. Gardner's writings. And then we have two attorneys. One's a zealous attorney that is very excited with this case. He's really helping out the alienating parent because he believes the other parent is just disgusting. And the child hates to be with that parent, and they feel they have a win case, and they're really doing the right thing to protect these children. And the harm to the child, that anything they can do to protect that child is serving justice, particularly depriving the parental rights of the targeted parent. And then we have what might be considered the confused attorney representing the targeted parent. Now, when you look at what attorney ends up with a targeted parent, it's either that they want to rise to the occasion and help that person, although they really have an idea of what to do, how can they help. They're out of their magic solutions and really don't know what else legally to do. Or they get stuck with the targeted parent that they didn't realize in the beginning of the case, and they're asking themselves, what do I do now? I'm on the losing side. I got this guy. The kids don't want to see him or her. And how can I represent him? And what they often conclude, let's get this case over with, collect their fee, their retainer, work out a settlement, tell the targeted parent, forget it. There's not much chance of any change, and this is where it is. Go to anger management groups and the rest of these things, accept supervised visitation. At least you get to see your child. So the attorney representing the targeted parent has a difficult job, and often the targeted parent has to shop and carefully find another attorney willing to rise to the occasion. And then in the mix of things, we have a judge. Judges, as others have said, do not like PAS cases. They're difficult cases for the judge. They go against the tide, and judges like to go with the flow of what makes sense and is easy. And how does a judge finally rule, okay, we're going to authorize a PAS evaluation? Well, either the attorneys agree upon it, or the attorney for the targeted parent is so persistent and unrelenting and challenges contempt motions after contempts that the judge figures, okay, I'll have to allow it just to get this guy off my back, and we'll turn it over to some psychologist that's going to do the evaluation, hear what they have to say, take the judge off the hot seat of always having to listen to a case or render an opinion about all these outrageous allegations that they have no basis for determining the truth or falsity to. Now, in the evaluation process and the presentation of the parties, some are easy to diagnose and determine that they're PAS cases and legitimate. Many others are quite difficult and confusing. It's hard to determine who's wearing the white hat and who's wearing the black hat. In cases that are easy to diagnose, a question that you might consider beginning with is asking the parties, what would you like to see as the outcome and recommendations of the evaluation? And as you might expect, the alienating parent will say, there's no hope for the other parent. I hope that they would get some parent training and learn how to be a better parent. But in the meantime, I need sole custody, sole decision making, and they need supervision so they don't further harm the child. And what are the recommendations and what is the hope for the targeted parent? That parent will say, I just want the other side, the mother, father, to cease the attacks and a reunification with my children or child so I can have some peace and harmony. That's all I want. And just tell the mother or father, whoever's on the other side attacking, to try to get along and co-parent what's best for the child. So those cases are easy to detect. Ones that are more difficulty or ones where you're not sure who's really presenting what story because the allegations are so far-reaching. And it's helpful to ask the parties to list what are the shortcomings and inadequacies and the problems of the other parent, and look for the various embellishments that they might offer, and list the other person's allegations and why they may be false allegations or why they may be true. And I find really looking for exaggerations. Are there realistic explanations, or are they trying to execute or eliminate the other parent, or try to rehabilitate with favorable or unfavorable prognostications? And generally, in the way that parties right up front present their case, you can sort of tell which way this is going. Now, in terms of the role of the evaluator, I find when it's a difficult case and I'm not sure how to approach it, I call a colleague of mine, Peter Falk, and many of you have seen the show Columbo, and he's given me some guidance about how to approach these kinds of cases. And in one case, I actually put on a trench coat. And I'm bumbling and stumbling. I said, this is really hard to understand. Why does the child just hate this parent so much? I'm particularly confused because when they were married, the mother or the father was taking the child to all these activities, and the neighbors report that they got along well, and now this child just despises that parent, doesn't want to have any contact with them. This parent must have done some pretty terrible, despicable things. And I encourage the alienating parent to elaborate. I encourage the child, tell me more. This is really hard to understand. The more I play out the Columbo routine, the more they fall right into it and embellish more and more. And I just push it to the point of absurdity. Well, I can understand this one. One of my cases I remember in Indianapolis, the daughter said, my father went out and bought this particular car without my permission. She was 14. I don't like the color and the choice of the car. I said, well, I can understand. After all, he drives an hour and a half to work back and forth in the car, and when you go out on the weekends, you would want to feel comfortable with the color of the car and the make with your friends. So his not including you, I can appreciate where this would be upsetting. Tell me some more. What are some other things your father has done in this particular case? And the child just goes on and on and on. And this is the most helpful way that I get a picture of what goes on. This particular case, I remember I asked the parents, the mother brought the two daughters, 14 and a 17-year-old, into my office, and I said, everybody's been using this term alienation, and can you tell me about your understanding of it? And the 17-year-old started citing Gardner. And I said, I'm going to take notes. This is pretty good. You really have a good understanding, and you've read all of the refuting arguments against his theory. So now that we've refuted it, we don't need to deal with alienation. Let's go on to some other things. And let's talk about why you don't want to have any contact with your dad and why all these years he's been just a terrible father. So this is the kind of thing. Some parents are prepared, some aren't. But if they are, I have an alienation questionnaire prepared for them. I give them, tell me all about alienation, what you know about it, who you've spoken to about it, so I know exactly where they're coming from. And it's generally more than internet. The mental health counselor has provided some information for them. So that's the role of an evaluator that I often select in terms of trying to get to the heart of the matter, where they will go to extremes to explain why the children, and that's often starts with one child, and then there's a ripple effect to the other siblings, don't want to have contact with the targeted parent. Then it's going through the basic procedure of any evaluation. Only when you do a clinical evaluation, it's focused on the history. When it's forensic, I spend a good bit of time doing two kinds of interviews. One is about the case, one is about the individual. And I let them talk about the case, present all their documents and findings of why they feel such and such is the case, and then move on to the personal history with the family background, family of origin, substance abuse questions, and along those lines that everyone's used to doing. Then the testing, and their parent testing, psychological test. And there's a wide variety of tests that are recommended in doing any evaluation. If you don't do testing, particularly using the MMPI, the attorney on the other side, or the judge, is going to say, why didn't you do testing? I find testing is useful only as a tool to gather whatever information might be supplemental, but never rely on a psychological test or even a battery to show anything. I find you have to rely on your own clinical judgment. And I used not only standardized testing, but forms from here and there, and use my own creativity depending on what the nature of the case is to enlist those kinds of particularly projective questions. A TAT format of some cards that are printed up years ago show pictures of a courtroom, and particularly a mother testifying. So I might say to the child, here's a mother testifying about your dad. What might the mother say about your father? Now, that's not a standardized test, but that generates a lot of helpful information that fits in with a particular PAS evaluation. So you have the psychological testing. The next part is collateral contacts. And I ask each party to list who they would like me to call. It's certainly more beneficial. I say if they're impartial people, teachers, pediatricians, rather than their family members and best friends. Although in doing this over the years, I find that often the alienating parent will give best friends and family members, and I find most useful information from these sources to help the targeted parent. In some recent phone calls I've made to sisters of the alienating parent and the parents, and what they say about the targeted parent is not questions of abuse and horrible conduct by that person, but they don't coordinate activities, or they used to be involved with the activities, now they're not interested in it, or they had an affair, or the things that are really not significant determiners. So then I go back to the alienating parent, and certainly in a report, isn't it interesting that the things that you report and the children report that are so terrible are not confirmed by parents or even siblings or best friends that usually would buy into this kind of scenario. So I find it useful even to go to those references that one might provide, not expecting to find much, but in the value of a conversation, pull out a few things that make it useful. The amount of time I spend with collateral contacts varies from 5 minutes to an hour, typically on the phone. If I find there's nothing there and it's empty, I thank them very much and dismiss it immediately. Whereas if it's valuable, I let it roll, and they keep talking, I keep writing. Now, with a collateral contact, you need to get written permission from that person to disclose information they provide to you, because it's not confidential. And in a form I created, I'm sure others create their own form, gives permission that this material is not privileged and may be used in a report. That way, when they see a reference to it down the road, there's no complaints. So collateral contacts are quite useful and important, a unique part of forensic evaluations that you don't do in traditional clinical evaluations. The nuisance, I might add, is getting appointments with these people, whether you have a secretary calling or you're calling, and the call is back and forth. It's hard to pin these people down. Then you have family interviews and observations. Now, an interview is different than an observation. You can interview a parent and child, and then you can observe them. So you pick up different kind of phenomenon. The observer, you sit back, and the parent-child feel that you have an easy time, but it's more difficult, as you know, because you're recording behavioral observations. It's helpful to interview and observe, children alone, parent and child, siblings alone, siblings with a parent. I also, when an occasion is possible, like to do a family interview, bring in both parents. Did that recently, and the mother brought up to the child, maybe you could ask your daddy about your sister, because he denies ever giving birth to this child, right? I mean, the mother did this right in front of a child, in front of me, observing this, which is certainly an example for alienation of that from that father, claiming that he had a daughter, that the mother, of course, befriended the alleged mother of the child and claimed that this was the half-sister to the birth child of the parents. So it's quite useful to meet with the entire family together, and then I meet with the targeted parent and alienating parent. And they rarely want to meet together and find various excuses for doing that. In Dr. Gardner's book, he recommends always using that procedure as an eye-opener. And if it's valuable, it can be an hour or two interview, or if it's not going anywhere, you can close it down after 15 or 20 minutes. Then there's the document review, asking each side to submit and their attorneys what documents you would like me to consider. And there was one case in which the woman, she was the alienating parent, submitted to me over 4,000 pages and told me there was more coming. And in reviewing the court proceedings, there were 3 judges. They all recused themselves, and there was no decision made by any judge on any of the volumes of reporting for this case. And this woman is submitting to me 4,000 pages, telling me in her cover letters, I expect you to read this and incorporate this in your report. So, of course, I told them in the preface, I now write prefaces to PAS evaluations, because what happens is in your reports, they want to go to the conclusions and recommendations. So I give them a good preface so that it whets their appetite. They have to read more. And in there, this particular case, I outlined that the mother was kind enough to provide me with 4,000 pages of material, which I carefully read through at the father's expense. But since none of the judges ruled on any of these matters, I certainly wasn't going to, and therefore I was going to put aside these matters and address the ones that I was involved with. So that's reviewing documents, police reports, school reports, medical, psychological. You always have to get prior mental health records, and the legal documents. And then once you digest all this, it's helpful at the end to have a follow-up interview where you can do your challenging. Then I always like to ask the question to the alienating parent, what if? What if the circumstances were different? What if the parent was supervised? What if they would take the children to different activities? What if you select a different kind of parent coordinator or what have you? Under what circumstances would you find it more favorable for the targeted parent to be involved with the child? And of course, they struggle with that and find that there are no circumstances that would be acceptable other than their hope in the future the targeted parent would be a better parent. What I like to rely on most in doing these evaluations is my own experience with them. And I try to set up a situation where I can observe that behavior directly with that parent and the child. So I don't have to report on third-party comments, hearsay. Try to think of a situation. One parent, when I completed the evaluation, the father said to me, "You had 2 interviews with the mother and the children. I only had 1. I'd like to bring the children back to confirm and further substantiate the findings I've told you all along." And I said to him, "If you'd like to do that, I'll go along with it, but I would need a letter from you making this request because I don't want to do any extra work unless you feel it's really important to do that." And he was kind enough to write me a lengthy letter, this is the alienating parent, explaining why he wanted to make sure that I clearly understood that the mother was an alcoholic and a terrible parent, neglectful, etc., with the children. So he brought in each child. He had his list of motions from his attorney that he helped compile a list of all the faults of the targeted parent. And he said he wanted to go down the list with each child. 2 sons, ages, trying to think, about 10 and 12. So he went down the list, starting off with saying to his sons, "You understand, your father only wants the truth. You must tell the truth. We can't have any lies like your mother does. And I'm going to ask you the question, and I want you to give an honest answer. Now," the father says, "is your mother an alcoholic? Yes or no? Tell the truth." And the child understands that that weekend have a fishing trip planned, and the father's already explained to the children, "If you don't tell the truth to this doctor and the questions I'm asking you, I'll be pretty upset and won't want to go on a fishing trip with you." Anyhow, you can imagine sitting there for a couple hours with each child as this father literally abused the children. And as I told the court in my testimony, it's the most difficult to observe this kind of direct alienation, emotional abuse with these kids, and the father saying, "See, he confirmed it. He said his mother's an alcoholic. He gave an example." So later in the interview, I let 20, 30 minutes pass, said to the children, one at a time, "Your father said something about your mom being alcoholic. Can you tell me a little about that?" The child says, "Well, I remember we went bowling with a bunch of our friends, and my mother had a beer at the bowling alley." "Well, do you remember how many beers, or are there other times she's drunk?" "No." "Well, your dad says she drives and drinks all the time." He says, "Well, I haven't seen that." So one by one, negating these allegations the father made, which were confirmed in quotes by the child. And the father concluded, shaking my hand and thanking me, "Dr. Sauber, now you've heard confirmations for all these things." So this is the kind of direct experience which is far better than third-party comments to observe it yourself. So you issue a report, and you like to think it's a bulletproof report. It's going right to the court. Let them get all their experts and try to find fault with it. good luck. So this report goes out, and what happens? 6 months go by. The judge hasn't even heard it. They're too busy with other things. Finally, the judge is going to hear the report. So you go to court and you testify. And it's a matter of getting the report into evidence. And judges don't like to read reports. So you have to go through the report in front of a judge to spoon feed them so that they rely on it and the evidence presented in such a way that there's going to be appeal if they don't pay attention to the report and the findings. I'd like to give a case presentation. I'm trying to judge the talk with the time allotted and talk about a particular case in which I was brought in as a retained expert. This is a case of a mother, father, and child, married 19 years. Child was 13 at the time. The attorneys involved got names of custody evaluators. My name was in the initial pool. I knew the attorney for the mother. My name was submitted. The attorney ad litem is a familiar name or term for those in the States. In Canada, it's a different name that's used. But essentially, it's the legal representative for the child. A guardian ad litem can be a layperson or an attorney, often is an attorney. In this case, the attorney appointed to represent the child was a woman that previously hired me as her PAS expert in a case. So she was familiar with PAS. She knew my work. She made sure that I was not selected as the custody evaluator and determined that someone else be appointed, which they were, and is often the case. So here we have a case where how can a child who, after 13 years of being attached and bonded with her mother, seen everywhere, doing everything together as a dynamic duo, all of a sudden pronounce that she is afraid of her mother, doesn't want to see her mother, rejects her mother for a litany of weak and frivolous and absurd rationalizations of deprecation in her seemingly barred scenarios from her father. Well, this is what happened. The parent coordinator that was selected for this case was friendly with a psychologist who is a clinical psychologist that specializes in learning disabilities and educational assessment. So he was selected as the court-appointed custody evaluator that was introduced to the guardian ad litem, and the team was selected. The evaluation took place, and the report was submitted by the court-appointed psychologist. There was a child psychologist involved, seeing the child, the parent coordinator, and the guardian ad litem comprised the team, all agreeing with their findings. The mother was pretty devastated, and her attorney sought out a national expert to consult on this case, what to do, knowing that this was a incorrect finding. And who did they find? A national expert in the field to bring in on this case? Dr. Michael Bone. So here this case emanates from Boca Raton, where I reside, know the cast of characters, and they find this expert in Winter Park, Florida. He comes in, meets with the mother, meets with the mother, the attorney, reviews the documents, and says this is a clear case of PAS, and this is a horrendous finding. So the attorney says, well, would you want to get involved with this? And he says, no, but I know a guy locally that would get involved with this. He likes these kind of cases. And sure enough, Dr. Bone was kind enough to recommend me. And here I am working with the attorney that I knew in the first place that recommended me to do the custody evaluation. And he said, meet with the mother. And I said, what I'll do is meet with the mother and see if Dr. Bone and I are in agreement with the findings. If so, we move ahead. If not, then the case is over and stop, and I won't proceed any further than initial interview. So I meet with the mother a couple times, review some documents, and it's announced to the team that I've been retained as the expert in behalf of the mother. I get a call from the attorney ad litem. Hi, Richard, let's have lunch. Well, I haven't had lunch with this attorney ever. So we meet at a restaurant, good way to get acquainted. And she says, well, what do you think of the case? I said, well, I don't really know. I just got started. I put on my Columbo outfit. Say, I'm really confused. I just know a few details. I'm really not sure what this case is all about, but maybe you could tell me. And she proceeds to tell me that she's convinced that this mother is abusive to the child, has no idea how to parent, and the father is a wonderful person and the father of the year. And I say, I would appreciate just a couple considerations. One, would you delay your report a few weeks to give me a chance to interview the mother and learn a little more about the case so you can incorporate in your findings and your report what I discover. It's always better to be included with the GAL than have her or him write a unilateral report without your input. Second favor I would ask, could I meet with the child with your permission since you represent the child? The attorney ad litem has the authority. We don't need a judge in this case to give the okay. I said, I don't mind. The father can be present, the child psychologist can be present, you can be present. Bring in the troops, whoever you would like, but I'd like to meet the child. Well, she said no to both of those. One, I can't delay the report. It's written and ready to go. And two, we have to protect the child. We can't have the child meet a person like you that's only had 30 years of working with children and may give the child some checkers and get the child to start singing. So I was not allowed to meet with the child. So anyhow, this attorney was quite convinced of, and said to me, I know that you're familiar with PAS. You're not going to find it in this case. You'll find there's abuse. And if you do, I'll eat crow. So next step was I met with the mother and started to do the evaluation. And I started to see what was going on. And I asked her to do one bit of internet research. She was good with the computer. And I said, would you find a nice, colorful picture of a crow? So I said, I'd like to deliver this to the attorney ad litem, either before or after the trial, I don't know which. And she came up with a beautiful picture. I mean, it's right out of National Geographic of this crow. So anyhow, what I did was I interviewed the parties involved and discovered that she was a battered woman, abused in every way, physically strangled by the husband, sexually abused, raped, forced to do all these unpleasant acts that she went along with just to please him and get him to stop harassing her, emotionally tore her apart. He was an absentee father. Until the time of separation, the daughter was hungry for his affection, approval, and acceptance, and he became the father of the year, and the daughter saw he had the power all along, so the daughter aligned herself with the father. What was also difficult was that there were 2 psychiatrists and a family physician involved in which this woman went to. Now, the psychiatrist, the custody evaluator and the psychiatrist found these diagnoses among the mother: bipolar, heightened anxiety, impulse control disorder, intermittent explosive disorder, passive-aggressive personality disorder, paranoid disorder, request to rule out delusional and borderline personality features. She's on antidepressant medication. So what do you do when you're faced with how do you eliminate all these findings? Well, the first thing I did was call the psychiatrist, who I had some acquaintance with, couldn't read their writing, and asked them to translate their notes. What I discovered with the two psychiatrists as well as the family physician, they remarked that the mother was rather shy and withdrawn, so the father, her husband, had to present the history and symptomatology of the mother. So essentially the psychiatrist took down the history from the alienating husband, parent, all about this woman. She sat there passively, which was her style, and depressed, withdrawn, and accepted the medication diagnosis of these doctors. Well, that's certainly useful information for my findings, as well as examining the testing and procedures for the custody evaluators. And you're asked often how do you take apart a report without attacking the evaluator, because you're not allowed to attack your fellow colleagues. And one, you start with the qualifications, and then you look at what tests they did. And I discovered in his MMPI with this woman, she was clearly paranoid, and he relied on that findings. And I asked the mother about taking the test and if she'd mind retaking it, and does she recall the instructions he offered the custody evaluator. And she said she just took it as a marital inventory about her marriage, and the custody evaluator never gave her instructions on the proper administration for the MMPI and how to answer the questions. So she took that test, came out clearly paranoid with an elevation in PA, and the custody evaluator relied on that findings plus the psychiatrist, and he proudly pointed out that she was a very sick woman, very disturbed, where my MMPI showed she was within normal limits, which was apparent by speaking with her, and she was battered in a significant way. I also selected a colleague, a psychiatrist, well-known and well-credentialed, to do a psychiatric just to refute the medical findings of the other psychiatrists and their diagnoses, and he, of course, found she was normal other than suffering some PTSD from battered woman syndrome. So anyhow, in the testing I did, in my report, I included 25 examples of battered women syndrome right in the body of the report, plus exhibits to make sure that the judge understood what was going on here, and appropriate documents, and also findings about the team that I asked the mother, tell me about the child psychologist, his name, background. And I said, let's call up the group where he works. And you give the name Mrs. Jones. It's a group practice. And just say you have a daughter and you'd like to refer to someone in the group who specializes with, let's say, 13-year-old females. Well, the secretary on the phone gave the names of 3 other professionals in the group. And then the mother said, well, I heard about this child psychologist. Could you tell me about, oh, well, he specialized in industrial psychology, consults with organizations. His specialty is hypnosis and biofeedback and stress management. Well, she said, well, that explains why this psychologist thinks that she's an abuser and has taken in everything that the child has said to the psychologist. Also asked for a copy of his course outline for his doctoral program. There were 3 sequences. Certainly there's one, a child and family, which he didn't take. His doctoral studies were in organization industrial psychology, never taking a course in child or the family. So here's a child psychologist 1 year after licensing, knowing nothing about children and families, with a finding that the mother is abusive, should have supervised visitation, the father sole custody, going along with the custody evaluator. The parent coordinator was one of these individuals that couldn't get any clients other than being a parent coordinator because of the infinite wisdom of criteria to be a PC in the state of Florida. They made the criteria such a stringent one that any senior person is not going to go through the rigmarole to have CEUs in other fields other than their specialty. So she was one that was more interested in social approval ratings and getting appointed. So she went along with the child psychologist, even though she had given the mother books to read about abuse and battered women syndrome, which she later had difficulty explaining why she gave the mother these books to read and yet found that she was an abusive and wasn't battered to begin with. So going into court, a report and taking apart the team, showing the GAL's findings are based upon the custody evaluator, and his findings are based upon some testing, the psychiatrist that never really interviewed the mother, the family physician that gave an affective disorder scale that he didn't really understand, and that the husband helped answer anyway. So that this team, in its united front, one by one, was shown to be discredited. And I testified before the judge. Now, what's a judge supposed to do? All of his court-appointed team comes up with one finding, clearly in behalf of the father, the husband, that he should have sole custody and the mother should have supervised visitation, which is already in effect recommended by the GAL. And here I come into court and testify the opposite. Well, this judge, as most family court judges, they're rotated. So this judge is new to the family court. He's been there a short period of time and sort of puzzled with what to do. So in his infinite wisdom, it took him 3 months to render an opinion, which was verbal. And what his opinion was, that he said he'll put into a written order, which is now 6 months, and there's been no written order, that the father have residential custody with the child and that the mother have standard visitation. Now, this is a victory in a sense that it eliminates sole decision-making, it eliminates supervised visitation, but it does give residential care to the father rather than the mother. So it's a compromised finding, but the judge couldn't put his pen to the paper and put it in ink because he knew he was wrong. He couldn't go back against the team. So it's an unfortunate situation that we frequently find of a judge not wanting to go against the tide and come up with a compromise finding. So at least there was some value to my getting involved with this mother, even though it wasn't the finding we were hoping for. Just to add a footnote, the testing that I did with the mother showed she was up in the 90th some percentile for passivity and submissiveness, and I had her do a inventory on how she perceived her husband. It didn't matter how he was, but how she perceived him. He was in the 99 percentile for dominance and aggressiveness, and another category of her ability to tolerate any frustration or dissonance. She was up in the 90 percentile for tolerance, but perceived her husband as aggressive, hostile, and intolerant. So you put these two together, and that's kind of a marriage and case that we're working with. So that would be an example of this particular case in which I was involved. I'll be available for additional questions during the break. I know my time's up, and Mr. Goldberg is here to continue. Thank you.
I'd like to introduce one of our sponsors this morning, Mr. Ron Rudick, who is with the firm Gorfine, Schiller, and Garden. He's going to provide the introductory remarks for our next speaker. Ron Rudick, please give a warm welcome.